Lloyd.
Thanks. Are we live yet? Oh, okay. So,
Doesn't show me. I went live. Yeah, we're live.
okay. So, good morning. This is the second hour of Senate Natural Resources and Energy. Today's date is Friday the 11th, and it's 9:37 a.m. We're resuming our work on Bill S-201, an act relating to the use of lake-hold traps. Based on our conversations this week, and particularly in the last 2 days, we have amended the bill to take a different approach, and that is to engage in the formal movement to best management practices through action of the commissioner, then in concert with the Fish and Wildlife Board. And in order to make sure we all know the details, I'd ask council to walk us through, please, S-201.
So this is Michael Gray, Legislative Council. You should have in front of you a draft that says draft 2.2, March 11th, 7:27 a.m. And the prior content of the bill, which was a ban on lake-hold traps, is being struck in its entirety. And in its place is a session law directive to the Department of Fish and Wildlife to submit to your committee, the House Committee on Natural Resources, Fish and Wildlife, and the Fish and Wildlife Board, recommended best practices for trapping and proposed criteria and equipment design to modernize trapping and improve the welfare of animals subject to trapping programs. The BMP shall be based on investigation and research conducted by scientists and experts at the department, and shall use the best management practices for trapping in the United States issued by the Association of Fish and Wildlife Agencies as the minimum standards for BMP development. Then it includes specific directives for what the BMPs shall include.
And can I, sorry, just a brief editorial comment. So I think in the end, we all said we would like to spend possible science and drive the discussion forward that way. So thank you for fleshing out like what that part of the lead in.
Okay, moving on, the BMPs shall include specific provisions, including trapping devices and components of trapping devices that are more humane than currently authorized devices that are designed to minimize injury to a captured animal. Criteria for adjusting and maintaining trapping devices so they operate correctly and humanely. Trapping techniques, including the appropriate size and type of the trap to target animals, use of lures or other attractants, and trap safety. Requirements for the location of traps, including the placing of traps for purposes other than nuisance trapping at a safe distance for public trails, class 4 roads, playgrounds, parks, and other public locations. The person may reasonably be expected to recreate. And then last, criteria for when live captured animals should be released or dispatched. Then the report shall include a recommendation from the commissioner for funding the replacement of currently authorized trapping devices with trapping devices that are compliant with the recommended BMPs. Commissioner's recommendation shall include alternative finance, public funding, private funding, or some combination of public and private funding. So that if it's not available through state funds, that maybe there are other funding sources that can be used. Page 3, line 1, in developing the BMPs, the commissioner shall provide an opportunity for public review and comment, and shall hold at least one public hearing regarding the proposed BMPs. I want to be clear, this is not rulemaking, it's just notice and comment and a public hearing prior to them submitting those recommended BMPs to you and the Fish and Wildlife Board. And then I included a definition of trapping so that there's a known intended universe of what the activity is. definition is actually the definition from Fish and Wildlife Board rules for what trapping is. Section 2 would amend statute. It is the authority for the Fish and Wildlife Board to adopt rules for trapping of fur-bearing animals. It would add a new subsection, which would provide that the Fish and Wildlife Board shall revise the rules regulating the trapping of animals in the state. The revised rules shall be at least as stringent as the best management practices for trapping recommended by the Department of Fish and Wildlife. Rulemaking is a living process. So things grow and shrink in rulemaking, but you're setting a floor for what those rules should.
Thank you very much.
I do see one necessary on page 3, line 9, that subsection A should be underlined.
Okay, fur-bearing animals.
No, just the A in the parentheses, because it's a new subsection.
Because previously that was the entirety of this section.
That was the entirety of the section, and now you're adding a new subsection.
Okay. If you can make that change and send us something at some point today, that would be helpful.
So you're looking for a motion?
Well, first I'd like to ask if the committee has questions for council about how it's structured, any of the language, and then I'd like to go to the committee.
I have a question.
Yeah.
Do I understand this correctly, that this will settle nothing? We're not asking the commissioner to develop rules. These will be recommendations that will be made to come back to the legislature.
Well, you're doing two things. The first is that recommended BMPs that come back to the legislature and to the Fish and Wildlife Board. And then you direct the Fish and Wildlife Board to adopt rules. So the recommendations from the department come back January of next year, 23. And then the board has to adopt rules by January of 24. So in 18 months, you're requiring recommended BMPs and adoption of rules that incorporate those BMPs.
And the rules are driven by this relevant statute. What statute would drive those rules?
The rules and the requirement for the rules is right here in section 2, 4861.
And the list of things we're telling the commissioner to take a look at.
That's in session law, but you are incorporating that list in those rules on page 3, line 16 and 17 by saying that the BMPs need to be at least as stringent. The rules need to be at least as stringent as the BMPs recommended by the department.
Okay, so we're sort of past, we are past the fall of the administration. We're not really directing anything, is that correct?
Well, you're directing the development of the BMPs, and then you are requiring the rules to be at least as stringent as the BMPs.
But we're not saying what the BMPs have to do.
Were you, yes, the BMPs are,
Right, so
we are.
I think the line that we're setting up here to me is that we've said that there is great expertise in the department. So we're not well equipped to define BMPs, but the department is. So let's recognize that expertise. And then Mr. O'Grady has included, maybe you want to,
Sure.
everyone has a copy of that, but I don't know if they perused it.
So in the directive, the requirement, section 1 requirement that the department develop BMPs for trapping, there's a statement that says that they shall use this document for best practice, management practices for trapping in the United States as the minimum standards for BMP development.
We have copies of that.
Yes, it's, do make copies.
Oh, you have it right there. Just back there.
Oh, yeah.
Senator Cantor.
So, all right, so that's what I thought you were gonna say, you know, and as we've heard, about 70% of trappers follow these and 30% don't, so we're really pushing that 30% and making certain it's more comprehensive group of people, you know, everybody would be involved, everybody would follow these.
Right.
Okay,
So
back to Senator McCormick's question.
Yeah.
Is there any direction? Or are we just giving it all to the agency? This is the minimum standard.
the minimum standard,
That's an important part. of this,
Yeah.
Right.
plus,
These are the directions that we're giving them.
Yeah, this is the minimum, this
Okay.
is the minimum standard.
although I think if, let me check with council, but not, that's a minimum standard. It's not directing the council, not directing the department to write BMPs that are exactly these. They
Understand.
But these are minimums. And so I think the whole, for me, part of the thing we're trying to do is find a clear and concise definition of a minimum set of BMPs as our foundation, then pass those over to the department with a requirement to write BMPs. Knowing that we sort of, I don't know if I want to say set a floor, but set a floor, it still gives discretion to the department to develop BMPs as they best see fit, but using that as the foundation. And then those recommendations are here specified in statute that they must be used by the board as the basis for their rulemaking, and that rulemaking may not be any less stringent than the recommendation of the commissioner to the board as well as back to the legislature. So that's the chain of command, I suppose.
But the most important thing,
Yes.
those that are saying, no progress is being made. This is now going to be the minimum standard in the state of Vermont, which is not being followed by all trappers. And it
Correct.
might even become more stringent.
Right.
Okay.
So I think that's all, yes, an accurate characterization of what we're doing. Thank you.
I have one question for you. Would
Okay.
you like to retitle the Is it right now, it's activating the leg hold traffic?
yes,
I think that would be good. Because this is about all traffic.
right.
That's another good point.
I would, so you're good at writing
Yes.
non,
Just give that to the lawyers.
non-PR like titles. What would you suggest? I mean, we're adopting for the adoption of best management practices.
So I think that inaccurately to the adoption of best management practices for traffic.
Okay. Yes,
Well,
please.
that definitely more reflects what this is.
Okay, so we're changing to.
Because I was going to call it point of germaneness, but now I can't.
Yes, we have to, page 3
Excuse me.
for traffic. Okay, thank you.
Right.
Mr. O'Grady for pointing that out. And for writing the entire draft. So now, like, are there any more committee discussion before we hear from the commissioner? Okay, so thank you.
Thank you.
And Mr. O'Grady, are you gonna be able to stay with us? Okay, thank you. So, Mr. Commissioner, good morning, thank you. I think your feedback earlier this week about an interest on the department's part, moving to best management practices, opened the door for us to say that we concur, and that's, we're using, I hope, respectfully, the department's expertise and knowledge, draft the BMP, We're using the board to actually go through the ordinary rulemaking process, which, as you pointed out, involves more public input, as in when they're doing their work, there's public hearings. There's also, once they go into the Administrative Procedures Act, the formal rulemaking in LPAR, there's another round of public comment and input. So I think for all interested parties, there's ample opportunity to participate in the rules to be developed. So with that, let me stop and just say, what do you think of the bill?
So I'm Chris Herrick. I'm the Commissioner of the Department of Fish and Wildlife. And this bill is a clear improvement from where we started. And I appreciate the committee's willingness to have an open and honest discussion about a fairly complex issue. I guess my only suggestion is, and I'll let you know that the Fish and Wildlife Board has received a petition from the trappers themselves. They voted as a group to submit a petition to the board to essentially do what this bill is looking to do, require that they go to the use of best management practices. And so I think that that's a good indication too, that we're moving in the right direction. And so my only caution or concern is that the bill might be unnecessary in that we're already moving in that direction. And, but that's my concern. The thing I will say is best management practices are going to be evolving too. And so when we do write rules and regulations, it'll refer to what those are so that we're not having to go back and, as things evolve and change. But the department and the trappers themselves are committed to having BMPs be the way of trapping in Vermont. A question I do have is regarding the funding. Is that a requirement of the department to come back with a request for the legislature to appropriate funds for the transition, or is it just to indicate that there is funding in some way? Because there are private organizations that are interested in already funding this.
So it's only a requirement insofar as that the report shall include a recommendation. So if it turns out that you've been able to find sources completely outside the department, and those folks have been engaged and say they're willing to participate, then you wouldn't need to. There is no requirement to appropriate in this. It's that you need to have a recommendation for how we would help assist the transition to all BMP compliant traps.
I just wanted to make it clear or have clarity around the topic that there's no presupposition that we must fund this with taxpayer money.
No, it's an open question.
Okay.
The phrasing here is alternatives financed with public funding, private funding, or some combination of the two. So,
Okay.
great. Well, thank you. I appreciate that. I guess for anyone who's in the trapping world that hears about this bill and that might feel that they've already made a meaningful petition of their own, because there is we have to navigate between two competing bodies of thought, one of which says that they've gone before the board and they haven't seen their petitions taken up and moved. I'm not assuming that would happen in any way, but I think for us as legislators, our task is to ensure that the conversation happens. And we want to defer to the department's expertise to be the primary driver of the BMPs themselves that will eventually travel onto to the
I
board.
understand that. And I just needed to point that out, and thank you.
Yeah, well, we, with complete respect, we appreciate the petition of the Trapping Association to make that petition. And I think it just means that we're all marching towards the same place. And I think it's good to have us drawn together on an issue because it has been the source of controversy that was pushing people apart. And I think one of our goals is not to have this be a divisive issue and to work towards bringing people together to find a solution that's better for everyone.
Well said.
All right. Any questions or comments, committee, for the commissioner? All right. So with that, then I would like, the chair would welcome a motion to, Mr. O'Grady, will you give will the new draft for those small changes have a new number?
It doesn't need to, I would change the timestamp though,
Okay,
so that you could distinguish it.
all right. Can we just give it a new number so I can say 2-3 and then people,
Sure.
there'll be no confusion for anyone pulling up? Okay, so we'll make those amendments to the title, and there is a change that sub A was introduced, so that also needs to be flagged as an insert. And that makes those are the changes for draft 2.3. So I welcome a motion to amend S281 with draft 2.3.
I'm not gonna move this one. So moved.
Thank you, Senator Campion. All those in favor of adopting amendment 2.3, Senator McCormick.
Just the amendment.
I put the chair on notice last evening that I would be voting against this amendment, but would then vote for the bill on the floor, having fought the good fight. And once it's a fait accompli, that I would say this would be the best we could do. I actually, having slept on that, I will be voting in favor of the amendment. I hate it. It's a terrible disappointment, not only to me, but to many, many, many Vermonters. But the legislative process is that the various clashing opinions and clashing interests and clashing wishes ultimately work out some kind of nexus, synthesis that is probably as close as we get to that amorphous thing called the will of the people. And I am willing to accept that this is the best I'm going to get, and it's not nothing. It is a step forward, and I thank the committee for its diligence and open-mindedness and willingness to work on this. So I will be voting yes.
Okay, well, thank you. Senator McDonald?
I spent a lot of time last night trying to come up with some reasons to vote against best management practices. And I couldn't find any.
Yeah, I didn't have any, I felt very comfortable with this. I did not have the struggles my colleagues did on this one. I think this is a good step in the right direction. Thanks.
It's not as far as some people would like to go, but it's definitely moving. in the right
Definitely
direction.
moving in the right direction, yes.
Okay. All right, well, thank you. I mean, I'll wait till we're done on this bill, but,
So I've made the motion to amend the bill.
okay. There's no more committee discussion, then I'd say all those in favor, please say aye.
Aye.
All opposed, nay. So 5-0-0 on making the amendment. And now I move to the report favorably, S281 as amended by draft 2.3 to the floor.
So moved.
Thank you, Senator Westman. Seeing, hearing none, clerk will call the roll, please.
Senator McCormick,
Yes.
Senator McDonald,
Yes.
Senator Westman,
Yes.
Senator Campion votes yes, Senator Bray.
Yes,
Thank you.
so that is 500. CMP. And I'll report the bill. Jude, so before we move on, I just want to thank the committee. We have more work in front of us still, but this has been one of the most contentious issues I think I've worked on in my time in the legislature. I've had well over 1,000 emails now. So clearly it's important to a lot of people, and I feel like our duty is to serve everyone, and I feel like we've listened carefully and served everyone's interest by moving towards the BMPs. And Mr. Commissioner, I really want to thank you for your repeatedly positive engagement and trying to find ways to come up with answers. You're facing the same challenge we are with competing interests, and I appreciate that you were willing and able to work with us to find a position we could both support. So that means a lot, and I hope it also means that we'll be able to do more work with you as time goes by, because I'm sure there are other things in the pipeline. One of which is already in front of us, and that is S281. So let's move on to that, and if council will rejoin us at table. S281 is an act relating to hunting coyotes with dogs. We have a new draft 4.1, and I ask council to please walk us through that draft.
The full draft or just the changes?
I think at this point, it'd be good to just do the full draft, and we can maybe highlight the changes as well, but just to remind everyone of what the package looks like.
Again, this is Mike O'Grady with Dutch Council. The first section of S281, the amendment would add 2 statutory sections to the provisions on hunting, basically fur bearers. And so the first section relates to hunting coyotes with aid of dogs. There is a requirement that no person shall pursue coyote with the aid of dogs, either for training or taking, without a permit issued by the commissioner. So currently there is no permit required for either training or taking with coyote with the aid of dogs. Commissioner may deny any permit at the commissioner's discretion. Commissioner shall not issue more than 100 permits annually. The number of permits issued to non-residents in any given year shall not exceed 10% of the number of permits issued to residents in the preceding year. Commissioner shall establish a process and standards for determining which non-residents are to receive a permit, including who will receive a permit if there are more non-resident applicants than non-residents. A non-resident may train dogs to pursue coyote only while the training season is in effect in the non-resident's home state and subject to the requirements of the parks and rules adopted under this part. This language tracks closely, not exactly, closely the language and rule for hunting black bear with dogs. Should I move on?
Yes, please. Senator McDonald.
Line 11. Where the commission may deny a permit, the commissioner's discretion. I often see this, the commissioners are given this, is this a standard protocol, whether it's deer hunting or fishing or other licenses?
It's not ubiquitous. It's not in every permit program, but it's in a couple of permit programs.
What's the rationale?
This is a limited program, with only 100 permits, and there may be demand that exceeds the 100 permits. So the commissioner will have to make some decisions. And instead of setting out standards or criteria for how to do that, you just give the commissioner discretion.
Well, in the case of this commissioner, I have no problem doing that. But I'm wondering, is that, in principle, is that good policy?
It's a good question, it really is. The question will become whether, if you set standards with only 100 permits and the potential demand, you're gonna get into the disputes about whether or not the commissioner should have given a permit to this person versus the next person. And if you set out criteria, you basically give those people an opportunity to object and claim arbitrary and capriciousness. And so it's a good question. It really is, because it is unfettered. It's at the commissioner's discretion, but it is only 100 permits.
Yeah.
And I can pull up some of the other programs that have that discretion if you would like.
I remember when we did standard offer for electricity and the commissioner was stuck on what you approved and they did it by lottery.
Right.
So that's electricity, this is a different thing, but same.
Well, all our administrators have administrative discretion. There's a certain area in which you just say, well, it's her call. And that's, but,
Okay, I'll ponder on this as we go through the rest of it.
yeah.
Senator West.
If I go 10 years out, say this stays in place and life doesn't, somebody comes in, they apply for the permits, there's more than 100 people that have applied, and the commissioner has somebody that has twice had their permit revoked, and the commissioner says, you're out. I would think that would be a good reason for the commissioner to have some discretion to be able to do that. And quite frankly, if there's more than 100 and he wants to cut out of staters, I'm fine with that too.
I think, so my,
How many are usually out given?
well, I think the 100, I think may be over the number subscribed. So let's check with the commissioner while we're on this point. And I also was comfortable with the idea of not trying to, micromanage the department,
Yeah.
frankly. The commissioner knows how to make decisions, so
And I'd be shocked if 100 permits.
So.
I think that-
Yeah, can you weigh in on this one?
I can, the 100 was, I think we all agree, was a little bit arbitrary because we don't know. Which is the whole point, why we wanted to, regulate this activity. It's, I think the language is up to 100, correct? There are a number of issues where the commissioner, I don't mean to talk about myself in the third person, but it's the position, has discretion. And while I appreciate the senator's comment that he has faith in me, I think there are a number of administrative and executive functions that do require judgment and discretion, and that's not uncommon. And that's part of the job. And if we try to legislate every possible decision out there, then there'll be no need to have an administrator. Maybe that's the goal, but I don't think it is. There has to be a certain amount of trust. And if somebody does act in a way that's not in accordance with, good management practices, I think they'll be called out on it very quickly. So I think that having the discretion makes sense. And it's also something we can revisit once we have the number of permits.
Here's my favorite discretionary authority of the commissioner. He can issue a free permit to the president and the vice president of the United States. Fishing or hunting in the state.
His discretion.
If you, I haven't used that one yet.
It depends on. the
I can't even issue a free permit to myself.
Ah,
Right. Okay, so, yeah, as the commissioner was just saying, it also struck me that we're just getting started. So rather than worry about criteria and stuff like that, that leave it to the commissioner's discretion, gain some experience. If it needs revisiting, we can come back. That was my take. Senator Kingston.
I just want to say again, I think this is another really good, solid step forward in addressing some of the concerns that people have raised. And this is, now we are monitoring and managing this practice, which has never been done before.
So if we're all set on the discretion question, then I think that takes us to
Well, the fee,
other feet, yeah.
on the top of page 2, for resident permits, the fee will be $50. For non-residents, they have to first apply with a $10 application fee. And then the non-resident permit is $200. That's pretty consistent with the resident versus non-resident breakdown in some of the fees.
Thank you. Any questions on that part? All right.
The next section is where there is a change in draft 3.2, which you saw not yesterday, then the day before. There have been 3 subsections in this section related to prohibited scenarios where it was prohibited to hunt coyote or pursue coyote with dogs. There had been a provision that said if a person, a landowner, previously communicated to a dog owner that pursuing coyote with the aid of dogs was prohibited on the land, then that was a prohibited activity. The chair wanted to basically refine that provision and say a person shall not release a dog onto land, whether the land is posted or not, for the purpose of pursuing coyote with the aid of dogs, unless the dog owner, the handler of the hunting dog, has obtained a courtesy permission card from the landowner or landowner's agent allowing the pursuit of coyote with the aid of dogs on the land. Effectively, that means that the pursuit of coyote for training or taking with dogs has to be by landowner permission through the courtesy permission card process.
And so thank you. The rationale, I think that was my understanding of what our discussions in committee were about. So, but I don't want to assume that. The argument for it in my mind is that this has been the area of greatest conflict. Hounds coming onto property where they're unwelcome. And so in order to not have to have individuals go out and find hunters and say, you're not welcome to hunt here, which is usually an after the fact event like the hounds have already been through. I think given how troublesome some of these confrontations have been and upsetting to people, that it's fair to say the burden falls to the hunter if they're going to come to that property, that they communicate to the landowner in advance and get the permission card, the courtesy card signed. And it also to me means that if a warden's called to look into a matter, it provides a basis for the warden to inquire as, do you have a courtesy card? And it's going to be clear one way or the other whether they do or do not, and they've been on that property. So it seems like it clarifies the roles, balances it, I'd say, towards explicit permission to be there. And I think that's may go a long way to addressing some of the bad situations that we've heard about. That's the proposal. I don't know, somebody has more thoughts on.
We should probably hear from the commissioner on this.
Yeah.
Thank
So-
you.
Yeah.
This is the one language change that is maybe a step too far. When I read that language, what I read is essentially for this activity, you've now essentially posted all of Vermont. And that is a very dangerous step to take because once you do it here, we all know what's going to happen. It'll get applied to all hunting situations. And if we really are considering at the very last minute inserting language that changes the intent of the Constitution, then I think that's a discussion that the whole of the state should have time to weigh in on, because this is setting a precedent. Because it is, let's be clear, you're now posting all of Vermont. And I'm very, very concerned about that.
Sure, and I think, well, Senator King.
So I share that concern. I'm just wondering if Ledge Council would weigh in on an interpretation, on the commissioner's interpretation of that language.
I think it's a fair interpretation because under 10 VSA 5201, posting is not just whether or not hunting is prohibited, it's whether it's by permission only. And so this is saying that for this type of hunting, it is by permission only. And so it's not the actual active posting, but it has the effect of that. So I would say it's a fair interpretation.
Thank you.
Yeah, but it's not, my understanding is that this does not require that the coyote hunter get permission to hunt coyotes. He needs permission to use dogs.
That he or she has to get a courtesy permission card in order to pursue coyote with the aid of dogs.
With dogs. So I'm not sure I'm convinced that that's posting the land. It has to do with the particular method that's.
Well, it does require permission for that form of hunting.
Yeah, so.
Yeah, I think that's a problem. I might be in the minority, but I think that's going to be a
I
problem.
think the one counter argument, so thanks Senator McCormick for that difference, right? It's not an outright ban on hunting coyotes. It's hunting coyotes with the use of dogs. So that's one meaningful distinction, because I think compared to every other form of hunting that we've heard about, other than bear hounds, we don't have the issue of control. If you are out on foot hunting, you as an individual, as a hunter, are very intentional about where you are. And the issue around hounds has been that they are often at a distance from hunters, and say a layperson would reasonably say, maybe not a lawyer, that those hounds are out of control because they're just running through, they're causing issues on upsetting animals, upsetting people, etc. So that was, that's a distinction I would draw between these. And then the last thing is, we talked about yesterday, committee, if you have this permission requirement, do you keep more land unposted? because now someone has the assurance that for this one type of hunting, hounds coming through, they will have to be asked, and they're comfortable leaving their land unposted. If we don't provide provision like this, does that mean that more people say, well, I don't want to be exposed to this, and so I'm just going to be proactive and post my land? So I'm not saying it's definitive one way or the other, but we did weigh out some pros and cons yesterday.
I'm worried about the constitutional piece and whether or not, I mean, I can, if you want me to tell the future, that's what the veto message will say. And I'd rather get something through that can, if Ledge Council is saying that that's a fair argument.
Yeah.
Let's get to the world of reality, and we're trying to do something for the next couple of years or next year while we get back and take a step that we know was likely to make place. That's
Do you have a suggestion?
No, I have a bill on the floor in the House, and I think they need me.
Okay, so are you able to come back?
I hope so. Do you?
Well, we have to be done by 11 and we need to vote. So let me just ask for, other than this one thing that we're getting hung up on, and I can explain the other changes we've made.
The other change is on page 3, sec 3, line 21, going on to page 4. And there was an intent provision that says it's the intent that the rules shall support the humane taking of coyotes, the management of the population in concert with sound ecological principles and the development of reasonable and effective means of control.
Okay, and those three, just so to remind people, we had a discussion about the intent of the rulemaking. We said, okay, I think there was support in committee for
Yes.
one. We wanted to support humane taking. We wanted to have that the management of the herd, I'm not saying that the department's unaware of this, in concert with sound ecological principles. And then because control became a bone of contention, we just moved it into the intent section. It says a reasonable and effective means of control, as opposed to getting into the whole thing about collars, whether they do or do not constitute control or as a sole means of control. Then the control section is now a new sub 4, a definition of control based designed to minimize the likelihood that dog pursuing coyote enter onto land that is posted against hunting or land where pursuit of coyotes is not authorized. So we're naming the outcome. We don't want hounds on that property. And please define control in a manner that supports achieving that. So to be very quick then, our prior draft did not had an A and a B and didn't put everyone into the category of needing a permission card. If we return to that, does that solve your problem, Mr. Commissioner?
I'm not sure what you're asking.
The posted in the prior draft?
We just, the floor is in recess, waiting for an answer to a question.
Okay.
Excuse us.
Prior draft, we distinguish posted from unposted land. The permission
I thought
card.
that was in the moratorium section, I think. And during that, I guess I think that new section that I just pointed out, that
Yes.
that Mr. O'Grady also concurred that is reverse posting. I think if you strike that language just completely, I think it's unnecessary. And it is problematic at the very least. And the other thing, I'm not a lawyer, but I'm pretty sure that bill would, if that became law, which I'm suspect to, it would see legal challenges. And, we have an opportunity to move forward here, but that is an anchor. And the one question I had for Mr. O'Grady, but he's not there, is does this permit allow, as does bear hunting, more than one person? It's not clear. And that we would need to make sure, because when people hunt bear, it's 2 shooters and a guide. And are we free to create those under the rules and regulations section?
My understanding of we'll have to wait for him to return, was that in this case, the intent was that the permit holder is the person we're talking about in terms of having an obligation to not release, but that it's not eliminating anyone else who might be in hunting party.
Okay.
From accompanying that individual.
Thank you for clarifying that.
So what, yeah, please.
In lieu of, and given what we've done with the other bill just before that, what if there was some instruction here for the department and the board to come back with rules through the regulatory process to push hunters to these hunters to get permits? And what steps could there must be steps we can take to encourage more hunters to get these courtesy cards and move in that direction.
Rather than just spelling it out right here in the bill. I think that's it.
Because I think
Yeah.
we might not be able to envision all of the situations that are out there.
Yeah.
It might, but give the department and the chance to think about this through the regulatory process, but instruct them to do something that moves this question ahead.
Okay, well, so thank you. I think that's one way to go. I just wanted to check our language, Commissioner Herrick, the language yesterday, that 3 sections that came to, Mr. Brady, if you could bring up yesterday's language on this. I don't think we ran into this problem until this change.
Right, so yesterday's language was based on Commissioner Herrick's proposal of the 3 types of categories of prohibited activity. The first was a person shall not release dogs onto land for the purpose of pursuing coyote, where the landowners inform the person with the dogs, controlling the dogs, that activity is not welcome. The second was a person shall not release dogs on the property for purpose of pursuing coyote on land that's posted without the landowner's permission, as evidenced by the courtesy card. And then the third was person shall not release coyote onto land if within the previous 365 days a law enforcement officer had informed the person handling the dogs that it was not allowed on that property. So that was the 3 provisions yesterday. A and B have been combined into just the landowner permission, regardless of whether or not the land was posted.
So Commissioner Herrick, if we return to that language, which I think of yesterday's draft, which had ABC, and I think we were intending to express exactly what you had laid out in your draft. Does that solve the problem from the department's point of view?
Without seeing it, and just listening, and I'll ask Mr. O'Grady, is that the language we proposed?
Yes.
Okay,
it's 98% what you proposed. I just had to change things based on our draft convention.
But it doesn't include this new language, is what you're proposing, Mr. Chair.
It includes the courtesy card, but only in the case of
posting.
posted link.
Yep. And if that's our language, and what I'm not sure what the 2% is, Mike.
It-
Mr. O'Grady,
It was the courtesy card, and then I have to change language so that it meets our requirements for drafting, so I had to do that.
Oh, all right. So it is not a change in
It's
intent.
not substantive, it's just.
Thank you. Then, yeah, I mean, if it's the language I submitted, then yes, I support that.
Okay. So I would propose we put back in yesterday's language and put Humpty Dumpty back together again. Sorry for the confusion. Thank you
No problem.
to everyone for raising the issue.
So just to be clear, I want to make sure I'm agreeing to what I mean to agree to.
Sure.
Um,
We can rescind the draft.
Yeah,
So if
Okay,
you
but on
look-
page 2, page 2, lines 8 and 9, for the most part, are no longer there.
You're right, if you go to the
Okay.
committee's web page yesterday and look at draft 3.2 on page 2 in section 5009, it will look like A and B did in 5009 yesterday.
Thank you.
thank you. So we'll, I'm marking mine to revert to the last draft in that section. And then I think that takes us, let me get.
So now, I don't have the language we're reverting to in front of me. Okay,
There should be a hard copy on your desk from
I'm
yesterday.
not sure if I paid them.
No, we don't have those.
Well,
I don't.
yesterday?
okay.
Anyway,
No, it's okay. I've got it online.
Okay, so the landowner has to more or less figure out who within so many miles of my house is likely to go hunting coyotes with dogs, and I'm gonna go and look them up and find them and tell them not to allow their dogs on my property.
Or they find the person with the dogs on their property and then inform them.
No, that's after the fact. So at least the dog handler gets at least one free pass.
well, I think I agree, it's not an ideal solution. My sense though, from Colonel Batchelder's testimony was that the wardens are very likely to know who has been in the area. And so I think they could assist in this matter.
I hate to say it, almost sounds, or not that it's bad, I just, the back and forth, it sounds like Senator Westman's proposal might be the cleanest,
Can you restate your proposal,
the
please?
most logical.
You know, basically with some structure, tell the department to,
Yeah,
through the rulemaking process, deal with this. I think what as a base of what you're gonna come up with is the proposal that the commissioner gave us yesterday, but, and I'd like to see him push the edges of that, but I think that the base of what they're gonna come back with is what he's
he's already
already
proposed,
proposed.
right.
But I
Haven't
think
gone through a
in
process.
the rulemaking process, that would give them some time to refine it.
Senator, to me, Senator McCormick's question just now, it sounded, and you know, it's the endless questions that we're gonna get. This is tidier, smarter, more direct, gives time to reflect.
Well,
That's where I'm at.
I'm amenable to that, so.
Can I ask a clarifying question? I'm having a hard time finding, when we are talking about what our yesterday's language was, it's only as it pertains to this section that we're talking about, right?
5009,
Yes.
yeah.
So we're not
That-
going
that-
back to previous versions now. It's hard, I'm getting a little confused because I can't find it on the website. Because I'm also trying to pay attention. But I want to make sure that we're not reinstituting ground we've already covered.
So, council, if you hear Senator Westman's proposal, is that enough direction for you to rewrite to address this issue?
And does it make sense?
Well, the rules do have permission provisions for other activities. Youth hunting, you need permission to go onto the land on youth turkey and youth deer. Falconry, if you lose your falcon, Senator McDonald,
Right, but she has.
you have to go ask the landowner to go search for your falcon on the property. There are landowner provisions, and I could, if at your direction, include a requirement that the board develop rules for requiring landowner permission for persons to hunt or pursue coyote with dogs, if that's what Senator Westman's indicated.
I'm wondering, might the commissioner weigh in? Commissioner, how do you feel about that?
I think that that's, again, the issue at hand. Our language is looking to address it. I think
Right.
putting in specifically permission for this activity is heading down a dangerous road, setting precedent. And so I think where Senator Westman was going makes a lot of sense in terms of keeping it general. I mean, it's specific enough that we need to look at how do we encourage, how do we promote that activity. Frankly, we do a lot of it already, but heading to the requirement, whether you do it, telling us to do it through rulemaking or just doing it like it's suggested here specifically, is dangerous and concerning. And so I like the idea of how does the department in its, how are we going to encourage more permission seeking in the hunting community?
I
please.
say that in the form that I think the commissioner has laid out the basis
Right.
where they would come to.
Right.
And, and we'll be watching that in that, but the details and how that happens will be done in a rulemaking process. So, and I'd like to say, instruct them through their rulemaking process to do something about this, but
That's what I like as well. And Commissioner, it sounds like that's what, that you would support that.
Agreed.
Okay.
As long as we're not being prescriptive, which I don't think you are.
Right.
Okay, I think we should be prescriptive. And I am not enthusiastic about encouraging permission. I think it's entirely appropriate. I think it's our job to require it. And I think we have another constitutional issue here, which hunting under the Vermont Constitution, hunting is a constitutional right. So is private property. And to kind of create a protected class of people who basically have permission, if not explicitly, then by our silence, to violate other people's property rights, I think is a constitutional issue. And I think a stronger argument can be made that, no, you can't go running your dogs over someone else's land without their permission. As a constitutional issue, I think is a stronger argument than saying if you have to get permission first and you don't have permission, then you can't do it. And that violates your constitutional right of hunting. I don't see how that violates the constitutional right to hunt at all. We condition the specifics of how a constitutional right is exercised. do it all the time. I have under the US Constitution, I have a First Amendment right to stage a protest march. I cannot do it on Shelburne Road at rush hour. That's not taking away my rights. It's regulating time, manner, and place. And so too here, I think we have to respect property rights of the landowner.
So how about one possible path I see is for unposted land that we would do this rulemaking. And for the posted land, you could still use the permission card. Is that, that ends up taking the one area of contention. We can be affirmative on the use of the permission card for posted land. And then, for the unposted land, have a rulemaking address it. So that it's something I think it pushes as far as we can without running into this sort of bigger issue. I agree. So I don't think we're in the right forum though for resolving that.
I can support that.
Okay. So could you draft, bring us back to the language we had for posted land, permission card required. And then for unposted land, leave it to a rulemaking.
But is the rulemaking encouraging or requiring landowner permission? There's different messaging on that.
I think the only way we're gonna get around the commissioner's concern is encouraging.
It's not as clear and definitive as I would like, but I'm willing to stick with encouraging because it moves us forward on the issue.
Can I ask this, is that lunch for us all, or is that a bag of messages from people?
Oh, it's food. I thought it was a bag of slips.
Did you bring enough for everyone? Because I'm hungry.
No, thanks.
Is it cookies?
It's actually, I'll be happy, once we vote this, I'll bring the food out. It's hot cross buns from a friend who works in a bakery.
Is that a Tim Ash kid?
What's that?
Tim Ash used to bring in all baked goods.
This guy's a part-time baker, and anyway,
So we're gonna wait on a new draft.
yes, we'll wait on a
Okay.
new draft, we'll revert to yesterday's. When it comes to posted land, we'll have rulemaking language centered on encouraging for unposted land. Okay, so
And the commissioner can get a copy emailed, and then we'll
Yeah.
also,
he'll have one.
great.
But we're not reverting to any language from yesterday. It's the rest of today's bill remains the same, correct?
That's not true.
I think,
The control language.
Yeah, that's exactly what I'm worried about.
okay, well, let's burn that bridge when we get to it. So on this piece, I think we're reverting to cards because we're using
Okay.
yesterday's language as posted land. All right, so let's continue on, knowing that there's more to do. I think we stopped at penalties.
So on page 3, going on to page 4 in the intent language, there is new language would say that in addition, the General Assembly intends that the rules require support the humane taking of coyotes, the management of the population in concert with sound ecological principles and the development of reasonable and effective means of control. So that is new language that does touch on control.
Yep.
And so I'll explain, since I worked with council on this, because we were getting sort of wrapped around the axle on do collars constitute or not constitute, they exclusively constitute a means of control. We took that provision out of the areas that the rule has to address, and then simply said up in the intent that we're looking for a reasonable and effective means of, that the rule should include a reasonable and effective means of control. And that concept there was, we have been hearing it, we should be deferring to people with field expertise and greater knowledge than ours, which we all acknowledge. So, but I thought that reasonable and effective means of control was a way of phrasing it that doesn't prescribe, but simply aims for an outcome. And I don't know if that seems helpful to the
I
committee.
don't think you need the word reasonable, but that's, I mean, it's really, you're looking for effective control, but it's
Well,
fine.
so I think I had it in there because of the council could weigh in here. I think reasonableness is like a test that we use in law, and I don't, that's why I was thinking that the phrase came to mind. If it's superfluous, then I'm happy to get rid of it.
I think it gives both the department and the board and the LCAR some flexibility in looking at a proposed rule and determining whether or not it meets the intent. So that I think is, will it have any true substantive effect? Substantive effect beyond that? Probably not. Beyond what the legislature believes is reasonable.
Okay, and any further discussion on that intent language? So then the other new one is the new sub 4 that used to be about collars.
Right, and instead it's a directive that there be a definition of control to minimize the likelihood that dogs pursuing coyote enter onto land that is posted against hunting or onto land where pursuit of coyote with dogs is not authorized. So there's no more reference to collars, how collars are used or not. So it is leaving that definition of control to the board with the directive that it minimize entry onto land that's posted or onto land where pursuit of coyote with dogs is not authorized.
And so, you know, the rationale for that one in my mind was, instead of getting hung up on gear and technical details, let's just express the outcome we want, which is minimizing the likelihood that dogs end up on land that where they're unlawful. And that's whatever rule they write should aim to accomplish that. I don't know that it could be any stronger than that. You'll never guarantee that no dogs cross unwelcome. But you could try to minimize the likelihood that it happens. Any thoughts on that? So, Mr. O'Grady, well, so Commissioner Herrick, do you have any thoughts on those two new blocks of language?
No, nope. I just like, I think I just want to see a final version of this.
For
But
sure.
I've raised my my issues.
Okay, well, thank you for that. Thank you for Senator McCormick for raising the constitutional perspective. And so
If I may just add, as I've been sitting here thinking that it's constitutional to have hunting seasons. It's constitutional to prohibit hunting out of season.
Right.
It does not violate the Vermont Constitution's right to hunt. And so too, it can say it is, you may hunt coyotes, you may not put your dogs on someone's land without their permission. That does not, I think it is clearly not unconstitutional. On the other hand, I think it is a constitutional issue if we regulate coyote hunting with dogs and don't protect the landowner. Essentially give the hounders permission to go on people's land without their permission, to bring their dogs on people's land without their permission.
Well,
I think that may be unconstitutional.
well, we're not giving permission. I mean, this current status quo is, there's no regulation at all. So, you know, if I get how there's unsatisfying things in here, I would like to be more assertive about obtaining permission. But for the sake of making progress towards regulating a problematic form of hunting, which has no regulation at all, I'm in the mode of compromise to make a start on it. And that's where we're at.
So I will note the Constitution says that any citizen of the state has the right on their land or on the land of others, unless that land of others is enclosed, and it is subject to regulation by the General Assembly. So there is a constitutional right to hunt on the land of others.
Is there a constitutional right to use dogs?
Well, it's to hunt and fowl. And this was written in 1786. And most likely when they were hunting and fowling in 1786, they had dogs.
That's correct. That is all accurate.
So.
Okay.
With that, what's a workable schedule for you, Mr. O'Grady? It sounds like we all need to see a draft, and then I'm more or less, we can vote that draft, but we all need to see it.
And we're on the floor just until 1,
Why not?
11 until 1. is that what
Or
they're-
depends on what we have for.
Yeah, actually, I bet it'll go until 1:30. That's when my committee.
So I will, so what's your schedule? Because I'll announce a brief meeting to make sure everyone gets a copy, and then we can we can reconvene to simply vote for, at the end of the day.
My schedule right now depends on what's going on the floor.
Okay,
Because I'm technically free, but if it's going sideways up there, I probably need to be there.
okay.
He can Zoom me and you can give me.
All right, so let's stay in
I can get you something by Jay.
by 2. Okay,
Noon.
so noon. Okay, great. So Commissioner Herrick, did you hear that?
I did.
We'll have
If somebody just wants to let me know when to pop back in, I'm, just like you, I'm stacked up too,
Okay,
but I'll make
Thank
myself
you.
available.
thank you for your flexibility. Sorry to have, another.
I know how this
curveball.
works. I know, and I appreciate the conversation.
Great, so committee, we are adjourned.
Are you coming back in?
Um,
We will be on the floor.
we will be on the floor. So I will announce on the floor when, we have that draft
I can do it at 4.
at 4. We might have
I'll be
time
done by
between,
4.
we might have time between floor and committee. That's what I'm wondering, if there's a window there, depending on how the floor.
Okay, I might be able to pop in,
Right. Well, you
but
probably
it'll
know
have to
where
be
you are.
fast. Yeah.
You're thinking more 1:30?
Maybe right, just before, what time does your committee start? 1:30?
Well, we're gonna, 1:15, 1:30,
Okay,
waiting to hear from one
so
witness.
maybe 1:15-ish, we're back here to vote. If we are off the floor. Otherwise, let's aim for the other end of the day, 4 o'clock. For the agenda, I would put down 1:15, and I would put down 4 o'clock.
Okay.
And it'd be